Good afternoon and welcome to our first forum for 2026 for property lawyers in Northern Ireland. Thank you very much for all attending, and thank you, Ian, for coming along to lead us. And I know Ian's got some topics to look at here, but really just to remind you, Stewart Title is here, hopefully as a partner to help you and your colleagues deal with title queries. We do have specific policies for Northern Ireland, and they're all accessible through our Stewart Solutions site. So very brief details here of Stewart Solutions. I'll just quickly show you how to use it. There is up to £20 million worth of cover for the most popular policies. There's around 150 different policies across the site, and a number which are specific to Northern Ireland. All of our policies carry 10% inflation cover for each of the first 10 years. So that should hopefully deal with any inflationary cover. If you buy a policy today for £350,000, in 10 years it'll be more than £700,000. So good coverage there. If for any reason the value has gone up more, we can always top up the policy for you. Very simple online system, which I'll show in a second. 3 steps to get a quote, and literally less than 60 seconds to order a policy. Where problems are more complicated, and often there's a development issue to them, or where you have higher than the available online, you can speak to our highly experienced underwriting team. You can either contact them directly, and we'll give you those details in a moment, or if you start a policy on Stewart Solution and realise you actually need some more help, you can get through to the underwriting team there. There is a message system on there which will allow you to add plans, title deeds, and more information about the problem you're seeking, and we can then respond to you. We do host a number of webinars and training sessions, many of them with Ian. Ian's just completed one this afternoon on AI, which obviously is one of those things in the shadows, yet another thing to confuse and bemuse lawyers. But as I think is clear from these forums, we talk more and more to people, it is now affecting how we deal with clients, and indeed how your clients deal with you. I don't know about anyone here, but certainly even as an insurer, we're already seeing queries from clients or from homeowners, which are clearly being generated by AI. So you really need to know how to deal with AI yourself and how to deal with inquiries that have been generated by it. It's one of those forums. We have ones for support staff. We also have forums for residential property lawyers in England and Wales and Scotland, if you do any work in those jurisdictions as well. Title insurance is, of course, a regulated product, and we are always willing to do training for you on the regulations to make sure that your staff are up to date with what they need to know, and obviously in what they should be saying to clients, and most importantly, what they shouldn't be saying to clients about how title insurance works. If you move to the next slide, Ian. I want to show you very quickly the search process here. You'd enter the property details on the first page and then come through product search. There are 3 ways you can search. You can use the search bar to start typing in words, and that will bring up a policy. If you started typing in the word access, that would bring up all of the access policies. There is a show all products button, which is a bit like an index, which shows the main headings. And there's also this button here, which is very useful, which is the most popular products. And these are the most ordered policies from all of our Northern Irish policies across the board. So that normally, despite the fact we talk about 150 risks being on here, in fact, it's usually somewhere around 15 or 20 policies that are ordered most regularly. This shows the most regular ones here. One of the improvements we are looking at with our PD team is to make this actually more interactive, and it would be the most ordered policies by your firm. For the moment, this is across our Northern Irish contacts and clients, but maybe one day we can personalize it even more. But that gives you a way to search. So you'd click on a policy there. All online systems are basically based on certain statements of fact and assumptions. And here we have the statements of fact for this particular access policy. So we have included here in the statements of fact some ability for you to change those. Previously, they were fixed, and if you couldn't answer them, you were immediately knocked offline. Now, particularly with statements of fact which relate to the time a breach has been in place, we now have options. you'll be able to go into that drop-down box and select 6 months, 6 to 9 months, and still stay online. And the system would then change, if necessary, the premium for it. So basically, you can mark all of these. As long as you're able to confirm all of these are correct, you can stay online. If for any reason you are unable to, you would get a pop-up message saying it's now been handed to the underwriting team to get back to you. But on the basis that you can tick all of them, we move to the next slide, please, Ian. And here you have confirmation of the cover, you have the quote, you have ability to download a draft. You can then email that, the quote and the draft policy, to your file, email it to the other side, to funders. Very simple there. And when you are wanting to complete the policy, all policies remain live on the system for up to 6 months. So you can come back at any time in that and date and issue them yourself. The drop-down box there for commencement date, you merely drop down to that and put in the date you require. We do have the facility for you to backdate most policies up to 30 days. So if you have the Friday from hell and you forget to put some policies online, you don't need to come begging to us. As in the old days, you're actually in charge. You can backdate it and issue the policy. If for any reason you haven't ordered a policy within 6 months, you can speak to us. The systems remain live behind the scenes. We don't actually ever write them off. So you can come back to us, as we do get sometimes people coming back 2 or 3 years later saying that the policy is now needed. We can then revive it and issue it to you. Next slide, please, Ian. So that's a very quick show of how the system works. But if you are interested in getting details for it, you can contact us via the Stewart Solution email address there, and we can send you login details. You can then go on and have a look around the system. There's no obligation to order. We don't have your bank details. There's no monthly charge. There's no minimum period. If you do order a policy at any time, then we will invoice you at the end of that month for those issued. Any other inquiries relating to Northern Ireland for bespoke or more complicated development issues, please get in contact with me. And if you have any queries about our services in England and Wales or Scotland, and indeed some in Northern Ireland, some in the Isle of Man, which may be of use to some of you, then please get in contact with the BD team there at that address. And if you have any queries about any further training and webinars we can do, we have done some in Northern Ireland with Belfast Solicitors Group, and we are always looking for people to work with there. If you have any queries about those, again, get in contact with me. But that's enough from me, Ian, and I'll hand over to you for the meat of the day.
Thank you, Rod. Thank you, and welcome everyone. Thank you for coming along today. Just on the slide there are some a flavour of some of the products that Stewart Title are able to offer, and do take up Robert's invitation there. Contact him and have a chat about bespoke policies that he and Stewart Title are able to issue on your behalf. Formally, on behalf of IQ Legal Training, thank you very much for coming along today. The purpose of this forum is to discuss any topics that you care to discuss. What I normally do is start the ball rolling by looking at some topics that I think are pertinent or important or significant. But you just put in the chat whatever you'd like to talk about today, and anyone in attending will happily contribute, or I will put my 2 pence in for what it's worth. If you want topics for future webinars or training or forums such as this, again, if you let me know, we can create courses that would be suitable for you. We can find speakers that are suitable and invite guests along to these events to happily share with you knowledge and expertise. So Robert was just mentioning we've had a forum concerning artificial intelligence, and we had someone, sort of a case management software company, so computer experts along to explain how AI was utilized in their product, and also a general discussion about AI, which we'll touch on in a second or two. So if you said to me, we'd like someone to come along to talk about mining searches, to talk about environmental issues, to talk about professional indemnity issues, whatever it may be, we have a raft of people that we can call upon to come along and present or act as a guest. I try and ensure that it's not all sales, that it is information that is useful for you as busy practitioners. So what did I want to talk about today? I first of all wanted to talk about AML issues and money laundering. Major issue, and to share with you a conversation that I had with someone on Tuesday evening. an individual, sort of friend of a friend of mine, discussing the fact that he was wishing to purchase a property for £850,000. He had £500,000, which he had received via a redundancy. Nice if you can get it. He had £200,000, which he had received via an inheritance from his late wife. The problem with regard to that inheritance is that £100,000 worth of the inheritance was in cryptocurrency. And then we had the real kicker, which was that he had his own savings currently in cryptocurrency. And the question that was put to me is, surely a conveyancer would be happy to accept cryptocurrency as a legitimate source of funds to facilitate his purchase. Before I explain my view, I would like anyone attending today to tell me whether, if that client was coming to visit you today in your office, whether you'd be willing to act. So just put in the chat, anyone willing to act? Anyone say they wouldn't be willing to act? Eamon, Seamus, Paulie, Richard, Philip, Neil, Alan, anyone? Would you act or not? Just put in the chat. While you're waiting for that, I had someone last week, I was speaking at a conference, and they told me about a tale of woe where they had accepted instructions on a purchase. The client was funding the purchase with a mortgage, was also funding it from legitimate savings that were currently held in a building society. Contracts exchanged, due to complete. Client has been told about the need to pay over the balance of the funds required to facilitate purchase, and at that juncture says, unfortunately, I've had to use the funds from my savings in order to pay for some repair works that have been done to my parents' property, and therefore I don't have the money in the savings account. I have, however, money in a cryptocurrency account. I can cash that in and utilize that. Now, I wondered whether this was just a sneaky move on behalf of the client. I was assured it wasn't, and it was genuine. But the question that was put to me is, what would I do in that situation? And as I explained to the firm, firstly, I would have ensured that when the client was taken on board, the client was aware that the firm could not, in any circumstances, complete a purchase using funds via cryptocurrency. So I'd warn the client at the start that can't act, and explain to the client quite clearly that if at any time circumstances change so that the funds that are disclosed to us as a means of facilitating purchase are not available, we would not be willing to replace those funds with cryptocurrency. So going back to the question, no one's put in the chat whether they'd be willing to act if a client, as my pal was suggesting, had those funds but was using part of or utilizing cryptocurrency to facilitate purchase. The answer to the question must be a resounding we can't act. I do know one firm in London that will act, but the vast majority of firms won't. Why won't they? Because the National Crime Agency and our professional bodies are urging us not to act on a number of bases. Firstly, where is the cryptocurrency based? If we're using, or our clients are using crypto wallets, where are they based? And the big issue, the elephant in the room, is assuming our client invests £20,000 in cryptocurrency, Bitcoin, for example, 5 years ago, who can prove that that Bitcoin has now increased in value legitimately to £140,000 or £150,000? There are now companies out there that will audit trail crypto funds. So what they will do is produce a report for you that indicates that they've ascertained where the original monies came from to acquire cryptocurrency. They will tell you whether a crypto wallet was used to facilitate the purchase. They will then produce a report for you showing that legitimately £20,000 worth of Bitcoin 5 years ago is now worth £120,000. They'll then show you the an audit trail with regard to any crypto wallet that's used to extract funds and place those funds into a standard bank account. So they'll do that sort of source of funds trail due diligence exercise for you. Two things: it's expensive, and second thing, and importantly, if that third-party entity gets it wrong, then you're on the hook for money laundering offences. So it isn't a defence to say we used a legitimate third-party company. In addition to that, you would have to show that you undertook a due diligence exercise with regard to their choice. Next thing, with regard to AML, if you're using any form of third-party software management system, whatever it may be, to do your AML checks, again, same principle applies. Have you audited the entity that's doing the checks for you? And do you and your fee earners appreciate that it is still your responsibility to check AML issues and to report suspicious activity? So the use of a third party to undertake AML checks for you when onboarding the client or during the life of the transaction will not exonerate you from any liability. It's important that fee earners concerned are aware of their duties and obligations and that they comply with their duties and obligations. And those duties and obligations would include notification of suspicious activity. And this is interesting. Suspicious activity is not criminal activity. It is something that you or a fee earner within your firm concedes is suspicious. So it could be the client that's changed funding for a purchase from savings to a third party. You know, great Uncle George is now lending me the £120,000. So therefore, I'm not going to use my savings that I've told you about that are in Barclays Bank, in my Barclays Bank account. Suspicious activity would be becoming aware of sources of income that perhaps are non-standard, becoming aware that income is being received and tax not being paid on it, etc., etc. So again, I repeat the point that where there is suspicious activity, there is an obligation to disclose, but it's disclosing your suspicion, not disclosing criminality. So the test as to what you disclose is significantly lower. It is for third parties, National Crime Agency or whatever, to then assess whether what you're saying, which may well be combined with what another entity is saying, means that this matter warrants further investigation. So be careful with AML issues, please. Make sure members of staff are trained. If you've got a locum coming in over the summer, he or she aware of your money laundering policies? Is your receptionist and your front of office staff aware of your firm's policies and procedures? Because it may be that they are meeting clients, dealing with clients, and discussing with clients the transmission of funds into your client account. Next thing, scoping the retainer. When was the last time you looked at your retainer? When was the last time you reviewed it? It's important to keep it constantly under review. And the reason it's necessary to keep it constant under review is that the conveyancing marketplace and our world is changing almost on a daily basis. As Robert alluded to, we've just earlier today spent an hour talking about issues relating to artificial intelligence. And as a consequence of that exploration with a number of attendees, there are certain things that I think are glaringly obvious. Number one, clients, the lay client is using AI to check and challenge information that we're producing for them. Number two, fee earners are using AI either within practice or outside for their own purposes. And number three, as far as AI is concerned, there is risk associated with its use. So let's just drill down here for a moment. Number one, does everyone who's attending today work for a firm that has an AI policy as far as its staff is concerned? So are you, Neil, and your colleagues entitled within work to use artificial intelligence, to draft emails, to respond to emails, to produce reports on title, to answer clients' complaints about the conduct of a transaction, to answer questions that clients raise with regard to reports that are sent to them? So does your firm have a policy with regard to the internal use of AI? And then secondly, whether you have such policies and procedures, whether AI is used or not, we need to think about what we tell clients in connection with its use. So we might, as a firm, have decided that we're not using it at all, in which case I think in our retainer, we should advise the clients of that fact. Where we are using AI for limited purposes, perhaps for legal research, etc., we should explain that fact and explain how its use for legal research will not endanger the client with regard to data protection and confidentiality breaches. And then where we are using AI, there should be a policy internally as to its use, what it can be used for, what it can't, what's the extent of its use. And the client needs to be aware of where we use it. And where we are using AI, do we then explain to the client, one, what we do with client data, two, that we're not exposing that data and thus rendering it vulnerable to confidentiality issues or data retention issues. So we need to do that with regard to our retainer. Other things that we need to do with regard to the retainer is consider what we're advising on. And again, yesterday I was speaking at a conference and there were people there talking about, giving tax advice to clients. We're not tax experts unless we hold ourselves out as being tax experts. We are required to advise clients about any taxes that are due in connection with purchase and potentially taxes that are due in the event of sale. However, unless we hold ourselves out as being experts in the particular area of tax that we've disclosed, our obligation is simply to give a general advice to the client and to recommend to the client that specialist advice is sought where appropriate. Very important to adopt that strategy and again to be careful with it. Other issues with regard to scoping the retainer, I think we're all pretty good at telling clients what we're going to do as part of the conveyancing process. I would like you to also explain to the client what the process involves, the documentation that the client could encounter, the documentation that you're going to ask the client to sign, and the significance of the signing of that documentation. I think all of that needs to be carried off and cleared off within the retainer. We should be telling the client what we're doing. We should be telling the clients the limitations relating to what we're doing in the conveyancing process. And I think we should also explain to the clients the things that we're not doing, that the client might expect us to do within the conveyancing process. Are we all confident that we do that within the retainer? I'm a great believer in providing ancillary information to the client about their purchase, the tenure that's being offered, and the unusual features of the transaction, rural properties, any issues that might be of concern to the client, what searches that we will be undertaking and whether any additional searches are required given location or given client objective. We should be explaining to clients the process and ensuring the client is aware of risk associated with that process. We should be telling clients what we're not doing. We're not going to be giving specialist tax advice. We're not going to be giving the client advice about state and condition of the property. We're not going to be advising clients about the commerciality of the transaction. In other words, whether the client is getting a good, bad, or indifferent deal. All of these approaches need to be carefully explained to the client. Within the retainer, if we can use third-party information to assist the client with regard to the process and procedure, use it. So if you've got websites that you can refer the client to that will provide background information, so be it. Where you are acting for a client who's acquiring a leasehold property, then information about leases generally, the inability to Airbnb let, problems with regard to pets, etc. We can front load the client with all of this information, which should make life a lot easier with regard to our explaining to client process and procedure as transaction progresses. So please have a look at your retainer and make sure that you are scoping the retainer realistically, that it's client friendly. Be aware that it may be necessary to expand the retainer. So if you're acting for me, you may in the retainer advise me that you won't be inspecting the property that I'm purchasing. If during the conveyancing process there's an issue with regard to boundary or some other feature, then it may be necessary for you to carry out an inspection. If that is the case, you need to expand the retainer to advise me in the retainer, I said I wouldn't be inspecting your property. As a consequence of a boundary issue, or boundary sensitivity issue, I decided it would now be appropriate for me to inspect. However, I will be inspecting the property purely and simply to look at the boundary issue, the boundary problem, the access road, or whatever it might be. You should never inspect a property in a residential transaction on the client's behalf without explaining to the client the purpose of the inspection and the limitations relating to it. Were you to inspect without that, then there's the potential for liability as a consequence of something that was missed during the inspection. Or there may be a perception on the part of the client that you're looking at other things, in which case there may be reliance upon you with regard to those other things. Again, caution. Next thing that I think I want to talk about is reporting on title and how you report on title. Do you all have a standard form of report on title? Richard, Eamon, Seamus, Pauline, everybody else? Standard forms of report on title? Have you seen that some of the search companies are now producing reports on title for you, and case management because companies are doing this as well? I was talking to a search company this morning that was now producing set wording for their search results that firms could utilize to incorporate into their report on title. Don't mind that. I don't mind using a template. I don't mind using a precedent form of report on title. However, some important rules. One, very basic rule, always ensure that your client receives the report on title, confirms receipt, confirms it's been read, and confirms it's been understood. Point number one. Point number two, make sure that you produce information about the transaction in a format that the client can easily digest. So I'm a great believer in interim reports as the due diligence process continues, rather than producing one final report before exchange of contract. Next, where the report is sent to the client, I would like the client to have time to digest it. And B, I want the client to confirm it's been read and understood. And I'd also like to invite the client to raise any questions that they may have concerning the report or interim reports. And again, I'm going to indicate to the client that it is a requirement of my continuing to act and to facilitate an exchange of contract that the client confirms that the report has been read and understood. I want the report on title to deal with the client inspection. I want you to advise client to inspect before exchange of contract, and I want the client to understand what that inspection is required to do. It is required to, first of all, notify the client as to the physical extent of the property being acquired, and for the client to check that what he sees on inspection is consistent with how the property is described or how the property is revealed on a plan. Two, I want the client to inspect to identify state and condition of the property, the caveat emptor or type of principle. Three, I want the client to confirm that any information that has been produced by the seller, be it replies to inquiries before contract or indeed anything else, the information within that document or documentation has been cross-checked against what the client sees when they inspect the property. Again, very important to check. And then finally, I want the client to inspect to identify if there are any third-party rights that I'm not aware of, having examined the title and having examined any disclosures made by the seller or the seller's conveyancer. Where the client inspects, the client should be told about what they need to look out for before they inspect and be provided with documentation to facilitate a reasonable inspection. And then I want you in the report on title to confirm that you've advised the client to inspect. You've been assured by the client that they have inspected and they haven't identified any issues or problems arising during the inspection. So what I'm wanting the client to do here is to report back to me what they've seen. Two or three points that I think are important here. One, as far as client inspection is concerned, your client is bound by anything that they see, and they're also bound by anything that they ought reasonably to have seen. If there is a third party in occupation of the property other than the seller, then the buyer is on inquiry with regard to that person. They should be asked who they are and what their status is. As far as the inspection is concerned, the client should understand the importance and significance of survey or valuation. And again, the client recommended to obtain the best survey they can afford. Again, in the report on title, I would expect you to comment on any issues relating to title that the surveyor or valuer indicates. Where a survey or valuation has been undertaken and you haven't had sight of it, again, I'd want to indicate in the report on title that fact and say to the client that there could be issues that a surveyor or valuer has identified that could warrant examination by you, but you haven't received the survey or valuation to enable you to make that decision. So, reporting on title, I like to see interim reports. I like to see a final report in which there's a summary of everything that you've identified in due diligence that's pertinent to client objective. And I want the client to confirm it's been received, read, and understood. The next part of my presentation really involves avoiding negligence claims. And there's some good news. First of all, professional indemnity insurers are telling me that the number of claims against residential conveyances has declined by approximately 6% in the last year. So in other words, either we're getting better at our jobs and thus reducing claims, or clients aren't making as many allegations of complaint as they have in the past, or claims in the past. I'm fairly confident it's the former rather than the latter. I think clients are just as anxious as ever to shout foul and to try and claim compensation than previous. Number two, as far as claims are concerned, it is the simple things that practitioners have failed to get right that lead to claims. So, failing to set out in the retainer the work that you're not going to do that the client might expect you to do. Setting out in the retainer the limitations with regard to the work that would be done. Point number one. Point number two, a failure to correctly check the title that the seller is offering, and a failure to identify where defective title insurance would be a fix rather than attempting to remedy the defect. With regard to defective title insurance, the important point is that you need to ensure that the client is aware of what a policy is covering. Client needs to understand the premium that the client is paying. The client needs to understand that the risk exists, the problem exists, and that defective title insurance might be a solution, but it might not necessarily be the solution. The client needs to understand what the policy will cover by way of protection. And this is the important point that I was wanting to emphasize this afternoon, the lay client needs to understand their duties and obligations that they owe to the title indemnity insurer. So if Stewart Title, having issued a policy this afternoon for the benefit of your buyer client, the client needs to understand their duties and obligations to Stewart Title arising from the insurance contract, their obligation of good faith, for example, their obligation not to disclose to third parties without Stewart Title's permission, the existence of a defect and or the existence of a defective title insurance policy. The client's duties and obligations would involve notifying Stewart Title of circumstances in which a claim could be made or possibly is to be made. And things to watch out for. I don't know, has anyone here dealt with an online auction? Selling a property as an online auction? If you are acting in such a matter and there is a defective title insurance policy, would you please speak to the insurer to check that they're happy that you disclose in the auction pack the defect in title and the existence of policy. If you can't get that confirmation or don't have time to confirm that information, you are under an obligation to notify your seller client that they and the auction house should not market the property as having a defect in title, nor disclose the existence of a defective title insurance policy. I'd be doing that when I take out the policy. I'd also be doing that when I close my file. So just reminding the client of the importance of complying with their duties and obligations owed to the defective title insurance company. And I'd also be saying to the client, these duties and obligations are permanent and ongoing during the life of the policy. So I'm closing my file now. I'm backing off with regard to this transaction. Your duties and obligations to the insurer continue. So important to get that point over. Next thing, with regard to avoiding negligence claims that can cause issues, do cause issues, failing to undertake searches and advise client about search results. Imperative that when searches are undertaken and searches are completed and come back, the client is made aware of search content. It isn't enough simply to give the client a copy of the search result and say, read it. There needs to be some form of explanation relating to it. As far as searches are concerned, consideration needs to be given as to whether or not searches require refreshing, where the transaction is stalling or is delayed. And clients need to understand that in certain circumstances, searches have limitations. Local land charges search, for example, property-specific, no form of priority. As far as land registry searches and other pre-completion searches are concerned, imperative to do searches in a timely manner, such that the search result can be carefully considered. And again, with regard to searches where there is a priority period provided by the search, it is imperative that that priority period is diarised, and I would always maintain it's diarised a week before the latest time for the search to lose effect. Other things with regard to avoiding negligence claims, documentation. When documentation is sent out to the client for signature, there should be an explanation as to what that document is, where it sits in the conveyancing process, and what you're going to do with it. And again, that has to be in a clear and concise manner, such that a reasonable client can understand. As I mentioned to you already and alluded to already, you're only required to give detailed advice or identify the extent of risk where you hold yourself out as carrying specialist knowledge. Without that, the only thing that you'd be required to give advice upon would be issues associated with title and title defects. But where, for example, an environmental search and report reveals contamination, or a water search reveals that there is a private water supply to the property, all you're required to do is to indicate to the client the existence of risk associated with that problem, not to attempt to determine the extent of that risk and the net diminution in value that your property will sustain as a consequence. So again, don't hold yourself out as an expert, and then these problems will not arise. No matter what you say in your retainer, you are always required to give advice to a client buyer in connection with anything that's materially adverse to their interests. So no matter what you try and cut off at the pass with regard to the retainer, there is a base level of service that is always expected of you. As far as limiting liability is concerned, you can only limit liability, again, insofar as it is reasonable. The conveyancing client is generally these days advised as a consumer, and then has considerable consumer protection arising as a result. Next thing, with regard to negligence claims, be careful where you're acting for more than one party purchasing a property, the doctrine of co-ownership. Make sure that clients understand that there's no such thing as a collective client. All clients are individuals that have individual needs, different levels of knowledge, different attitudes and philosophies as far as risk is concerned. You can only act for collective clients if the collective clients have the same common purpose, and provided that there isn't any form of conflict of interest. If you're acting for co-owners purchasing a property, then again, that always needs to be borne in mind. And you always need to be aware that there is the potential for a conflict of interest to arise. And if that is the case, you'd have to say that you can't act. Where you do act and someone sustains loss, then you're potentially going to be liable in negligence for that loss. Next thing, with regard to avoiding negligence claims, talk to your insurance broker or your insurer and see what data or statistics they've got with regard to claims. See what's coming out there. Howden insurance brokers that I do a lot of work for produce what used to be a quarterly newsletter. It's now a twice yearly newsletter that indicates what's causing negligence claims. It's well worth having a look at that and digesting just what is causing problems, because that will then give you an indicator as to where risk assessments, where tighter compliance or tighter triaging the client and onboarding the client is going to prove and generate dividends. So again, caution, the sharing of the data is really useful, and ensuring that data that you receive is sort of addressed to the issues that you're dealing with would again be really useful. Do you all use co-ownership questionnaires? So Alan, Neil, Philip, do you use a co-ownership questionnaire in which, if you're acting for me and my partner, you ask us questions about our status, about our financial position, about our current financial arrangements, and about future financial arrangements? You should always do that. And you should always ensure that you protect clients where clients are not, or sorry, where clients are asking you to draft documentation which is inconsistent with contributions, etc. Philip, only you did say in private practice, but not now. So Philip, I'm assuming in what, local authority or in house? Anybody else use co-ownership questionnaires? If you don't and you want to see one, drop me a note and I can send you details. Yeah, local authority, right, got that. But they are important, okay? But the other thing is the procedure used with regard to co-ownership, important. What I would do is always dissect or obtain from the client as much information as I can about their circumstances. And ideally, I want that in writing, and ideally, I'd love that in the form of a co-ownership questionnaire. I'm then going to email the client and say, look, these are the choices that you have with regard to co-ownership. And then ask the clients to confirm what they'd like us to do with regard to drafting documentation. I hope that what they are going to ask me to do is consistent with what I would recommend to them to do. Yeah, well, we'll come back to that point in a moment, Philip. Where the clients are being inconsistent with regard to instructions, as Philip mentions, you would refuse to act. Where the clients are singing from the same hymn sheet with regard to instructions, then you can act. However, where, Philip, I've been asked by a client to create a deed of trust, for example, on the basis of an 80-20 split of beneficial interest, whereas the reality is that I know that the clients are contributing 50-50 towards the cost of the property, and thus the beneficial interest should be divided equally. I'll warn the clients about them instructing me to proceed. Some firms will say we just can't act in that situation. Well, I can quite understand why you'd adopt that strategy, but I would advocate that you can act as long as you warn the clients very carefully about what they're asking you to do and what the consequences are. And the consequences of drafting documentation that's inconsistent with actual contributions is that if a party is aggrieved, or if a party suffers detriment as a consequence, then the potential for a client to make a claim against you increases quite dramatically. So be careful. The last topic that I want to discuss today is what we were discussing earlier with regard to artificial intelligence, and this point that we should have policies and advise clients that we're not using AI, and make sure that fee earners are aware that they cannot use AI in connection with their legal work within your firm, or advise the client that you will be using AI, but explaining limitations relating to it. And if you are using AI, you want the client's authority to enable its use. So you want to disclose to the client you're using it, want to disclose to the client limitations with regard to its use, and you want permission from the client to use it. Now, there is a book, I don't know if you can see that, probably not showing particularly well, but might show, I don't know. The Law of Artificial Intelligence, written by Matt Hervey and Dr. Matthew Levy, KC. It's in its second edition and published by Stewart Maxwell. And this book gives you the definitive guide to AI in the context of the legal world. And it mentions a number of things. One, that we're under an obligation to inform inform clients that AI is being used to deliver a service, or that a professional person within your firm is being assisted by an AI system. So it's not only communicating that you're using AI, but which I think most people would do, but explain to the client the role of AI in our work. If we are using AI, we've got to be confident that we have assessed the product to ensure there is data security and also to ensure that client confidentiality isn't breached. With some open AI, we've got to be really careful because AI will learn as a consequence of sharing data that we input into the system. And therefore, you're seeing some AI systems that are siloed. In other words, the AI can only be used it can only be used within the silo. So it can't be used for learning out with the silo. You've also got to be careful with AI if you are using an AI service as to where it's based. There could be jurisdictional issues. Other things that I think important, you can seek to rely on wording to exclude liability for errors made by an AI system if you're using it, or to limit liability. But again, anything that excludes liability is likely to be subject to a reasonableness test. And I think you also need to be careful about where you're limiting liability or restricting the value of claims that can be made with regard to your use of AI. And there are Unfair Contract Terms Act issues with regard to disclaimers in that context. I just want to refer you now, if I can, to the professional obligations that arise with regard to the use of AI. So I'm just going to go through this with you. If I just find the page again, because I found it really useful and very important. Just looking for the page, I've lost it, which is fantastic, isn't it? So sorry about that. Important to appreciate the following. AI can be used in the legal profession for the following purposes. 1, data analysis, due diligence, document augmentation, document review and disclosure. It can be used for legal research. It can be used to predict legal outcomes or provide legal advice. It can be a case management tool. It can provide written and oral advocacy, and it can be involved in judicial decision making. As far as its current use is concerned, what I see is as follows. Used in part with regard to due diligence, which searches are appropriate, what searches reveal. To trawl data with regard to searches, scrape data and put it in reports and titles. 2, and that I would contend is document automation. For document review, again, AI is being used by lots of organizations to produce reports on title, to produce templates for report on title, etc. Going on from that, as far as legal research is concerned, I think that's the most common use at the moment. So we'll go off and we will produce a report on a right of way or a report on an easement, having used AI to assist us in that purpose. I am not seeing the provision of legal advice via AI directly. However, I am seeing firms using a chatbot to answer clients' questions. This can be on a sort of website, and the questions can be of a more generic or general nature, but notwithstanding, issues with regard to compliance, disclosure, etc., would still apply in those circumstances. I'm not seeing AI replacing the fee earner and actually sitting down or virtually sitting down with the client and giving advice yet. AI is used in case management tools. It is used in written and oral advocacy and judicial decision making, but it's at very early stages in connection with those latter 2 categories. So promise me, you will have a look at what you're saying in your report on title and in your retainer about use of AI. And if you are using it, you explain to the client the limitations with regard to the use and the protections that you've got in place. You are required to assess the AI system that you're using and to keep that system under constant assessment, given how quickly things are changing. Again, I recommend that book to you. If you want to see AI in operation and how it will impact on the legal profession, there's a book written by Richard Susskind called Tomorrow Lawyers, An Introduction to Your Future, and I would recommend that to you. It's an interesting, it's quite a pleasant read, to be honest with you, amazingly. The last thing I want to talk about today, unless anyone has any topics to put in the chat, are issues concerning cybersecurity. I think it was either 2 weeks ago or 3 weeks ago, I attended a conference on technology, really, but there were two speakers that were talking about cybersecurity issues. And I was pretty scared by what I was told. Number one, you can get insurance to protect your firm from hacking, ransomware, etc. Premiums are quite high. I thought in my naivety that where you were to be hacked, it would be a relatively simple task to cleanse your system and get you up and running fairly swiftly. And that all was necessary is someone with a bit of technical knowledge to sit alongside you and assist with regard to cleansing. I was told about two situations where firms had been subject to a cyber attack. On one occasion, it cost the firm's insurers nearly £500,000. And in the situation, it cost the firm itself, because it didn't have cyber insurance cover, nearly £750,000. Scenario number one, firm has its email system hacked, and hackers get into the system, but all they do is they simply watch traffic, watch emails. They do this for 6 months, and they're looking at a number of firms, a number of partners' emails, and they're just sitting and looking and watching. They identify one of the partners in the firm who's doing a lot of high-value residential conveyancing. They start taking a particular interest in his emails. They're constantly, on a daily basis, watching what he's saying. They create a new email address, which is very similar to that partner's email address, incredibly similar, but not the same. They then see that this partner is going on holiday, and they see that during the vacation period, there are 12 transactions where there is to be an exchange of contract. This partner deals with high value sales and purchases, so there's some fairly big money sloshing around with regard to purchase and sale prices. The partner goes on holiday. The firm, the scammers immediately email clients to say, we've changed email address. This is my new email address. Okay. And I am on holiday, and therefore you will be receiving communications from third parties, either from this email address or elsewhere. Email number one. Email number two, you're about to exchange contracts. I need deposits from you to facilitate the exchange of contract. Can you please dispatch funds into an account? That account is not the same as the account that the firm notified their clients to be utilized at the start of the transaction. So when they're onboarding the client, they say, our client account is Bank of Ireland, client account sort code, etc. But the client now gets a communication to say, change of plan, this is the bank account. 8 of the 12 clients contact the firm to say, what's going on? The firm says, we've got no idea what's going on, but certainly do not pay money elsewhere. 3 of the 12 contact the firm to say, you've asked me to change the bank account details for your firm. I was told at the start not to do that. Can you confirm that I can? And the money should be paid into the new account. So those 3 were swept up, and again, we're told don't do it. Okay. The firm then looks at the partner's emails and thinks, don't get what's happening here. They don't realize that there is a new email address that clients are communicating with the client, with the firm that's on holiday. One of the clients sends £100,000 by way of deposit. It cost the firm's insurers, I think it was £560,000 to sort out the mess. They had to stop all emails going out and had to set up new email addresses for every fee earner in the firm because they didn't know it was limited to this one fee earner until a forensic specialist comes in and spots what's happened. That firm now monitors any emails that are forwarded from a firm's email address elsewhere, and have put in a number of other measures to stop this sort of problem happening again. The second issue that I saw was a firm whose server was hacked, right? So nothing to do with an attack on the firm's technology. It was the server that was attacked, okay? And I think there were 9 clients of the server, not all law firms, hacked, okay? And so Fiona's going to the office Monday morning, all the systems are down. The senior partner in the firm gets an email to his personal email address saying, we've hacked into your system. We've, over the weekend, looked at lots of very interesting information about family clients, about private clients, about their wealth, about their assets, about current transactions, all of which could very easily go on the dark web. We're also aware of the fact that what we've done has created you with a major problem with regard to business activity. Therefore, what we want is, and I forget what it was, £400,000. We're not going to be greedy. We just want £400,000. Give us £400,000. Nothing to worry about with regard to commercially sensitive or personal information that's sensitive going on the dark web, and we'll get your system up and running within hours. This firm again has insurers, notify insurers. Insurers come out and instruct solicitors to deal with the matter. But again, instruct an engineer to see what's happened with regard to the system. The insurer says the easiest and cheapest way of sorting this out is to simply pay the ransomware attackers, which is what they did. They had to get authority from the National Crime Agency to do it because, in essence, what was happening was money laundering, money paid into a Bitcoin account somewhere from the Far East. The moral of the tale is please, please, please be careful with cybersecurity, with email addresses, with having systems and processes to protect your firm and communications with third parties, and to make sure that you've got insurance. The amount of money in that second hack dwarfed what you had with regard to the earlier one. So in my naive state, I thought if you were hacked, £50,000 or £60,000 to get you sorted out, maximum. I've got that sadly wrong. Be careful. Does anyone have any topics they'd like to explore? It is nearly 3 o'clock, so we're just about finished. Anyone burning issues? While we're waiting, a massive thank you to Robert Kelly and Stewart Title for sponsoring today. Do speak to Robert and do contact Stewart Title for defective title insurance. You may have another insurer, but Stewart Title may be able to offer a more competitive quote, or might be able to assist you when your existing insurer cannot. And if you have any topics that you'd like to explore on future occasions, or like people to come along to speak at these forums, please drop me a note and I'll endeavour to arrange for experts, guests, etc. to come along. Email address for me shown on slide there. So before we finish, does anyone have any topics that you'd like me to look at? Any topics that you want to explore today? Final question of the day. No one has written much in the chat other than Philip today. Has this been of interest to you? Is it of use to you if we go forward and do more of these things? Could you please insert in the chat what you think? That would be really useful for me before we finish. Could you do that? And while I'm waiting for that, what I'd like to do is first of all to thank Mr. Robert Kelly for his time attending today, for your time attending today. And again, I'm really interested to know if it's been of value. So if you could type that in for me, that would be great. Thank you, A1, very kind of you. Anybody else? Or are we barking up the wrong tree, or should we be looking at doing something different? Again, happy to concede that we've got it wrong, and happy to look at doing something different. So Seamus is typing. Thank you, Seamus. Scholarship questionnaire, yeah, get that sent out to you. Just drop me a note by email at the email address shown, please. Again, just waiting for Seamus and Pauline. No problem, Sean. Seamus, fine. Good. All right. Great. Well, look, we'll assume that's positive, and we'll press on. All right. Thanks very much indeed, everyone. Really nice to talk to you. Nice to hear from you, etc. Have a lovely day. Stay safe, and we'll speak soon. Thank you. Bye-bye.